Hey, it's Mark here, and welcome to the next edition of the Employee Survival Guide, where I tell you, as always, what your employer does definitely not want you to know about, and a lot more.
Welcome to another episode of the Employee Survival Guide, produced by employment attorney Mark Carey. Have you ever wondered what it actually takes to prove workplace discrimination in federal court?
I mean, really prove it, not just feeling wronged, but actually proving it legally.
Right, exactly. Because, if you're listening to this, you might assume that if you have a documented history of success and witnesses and a blatant double standard, the legal system will just naturally protect you.
Oh, absolutely. People assume it's like a math equation. Good employee plus bad boss equals justice.
Yes. But today, we are looking at a case that completely shatters that assumption. We are going to explore how complex, frustrating, and honestly incredibly subjective that whole journey can be.
Yeah, the reality inside a courtroom is really a battle over interpretations. It's about timelines and honestly the exact words you happen to choose in, like a mid-morning HR meeting.
Which is terrifying when you think about it.
It is. Because people who haven't been through the federal litigation process, they often think of discrimination in these stark, undeniable terms. Like a cartoon villain announcing their bad intentions to the whole office.
Right, like, I am doing this because of bias.
Exactly. But the modern workplace doesn't usually operate like that. And the legal mechanisms designed to police it are just full of these procedural traps that can catch even the most diligent employees completely off guard.
So to understand how these traps work, we have a fascinating stack of legal documents today. We're looking at the lawsuit of Amanda Brooks versus Bright Horizons.
It's a really incredible case study.
It really is. So we have the plaintiff's highly detailed 38-page amended complaint. We also have the 2025 District Court opinion from the Southern District of New York, which, spoiler alert, essentially dismissed her entire case before it even got off the ground.
Right, just threw it out.
Completely threw it out. And finally, we have the brand new June 2026 Second Circuit Court of Appeals ruling that swoops in and dramatically changes the outcome for some of her claims.
Yeah, and what we're going to do is unpack the entire timeline of Amanda Brooks's employment, right? The specific allegations of differential treatment she raises.
And more importantly, we're going to look at the underlying mechanisms of the law, because we need to understand how two different levels of the federal judiciary can look at the exact same set of facts, read the exact same words on a page, and arrive at completely different legal conclusions regarding what actually constitutes a valid claim of racial discrimination.
It's a wild ride. Where should we start?
I want to start by building a profile of our plaintiff, Amanda Brooks, because her baseline level of competence is basically the foundation of this entire legal dispute.
Oh, absolutely. You have to establish who she is as an employee first.
Right. So according to the 38-page complaint, Amanda is a Black woman with over 15 years of teaching experience. She isn't just someone who took, a summer job at a daycare. She graduated from Boston College with a degree in English, found her passion for early childhood education, and deliberately chose to make this her career.
Which is a huge detail.
It is. She went back to school, earned a master's degree from Hunter College, specifically specializing in early childhood education and teaching.
And that educational background is a crucial detail for the legal narrative, too. It establishes her as a highly trained professional. She understands both the pedagogical theories of early childhood development and the administrative rigors of running an educational facility.
Right. She's an expert in her field.
Exactly. When evaluating a discrimination claim, courts often look at the employee's qualifications compared to their peers or, their replacements. Brooks is presenting herself as a top-tier candidate right out of the gate.
And her initial performance backs that up entirely. So in July 2017, she joins Bright Horizons. And just for context for you listening, Bright Horizons isn't a small local babysitting service.
No, it's a massive publicly traded corporation.
Huge. They are a corporate provider of daycare services and early childhood education, and they often partner with large corporations and hospitals to run their on-site facilities.
Right, the stakes are very high.
High stakes, high pressure. So she comes on as a director at their West 96th Street location in Manhattan. And by all accounts in the complaint, she just excels. The teachers, the staff, the students, the families, everyone loves her.
It wasn't just popularity. She had the metrics to back it up.
Yes. She receives stellar performance reviews, and it all culminates in her winning the company's Rising Star Award in July 2019.
And the complaint highlights specific programmatic changes she made, too, things that benefited both the employees and the corporation's bottom line.
Right, which is rare to find someone who could do both.
Exactly. And this is a deliberate legal strategy. By detailing her innovations, her lawyers are preemptively dismantling any future argument from the defense that she was, somehow an underperforming employee.
So let's look at the mechanics of those innovations, because I find this fascinating. Anyone who has ever worked in shift work or retail or healthcare, you know that scheduling is an absolute nightmare.
That's the worst part of management.
Right. So Amanda devises and implements a flexible scheduling model at her center. Now, why does this matter to a massive corporation? Well, in childcare, you have strict, state-mandated teacher-to-student ratios.
You can't just wing it. If a teacher calls out, you have a huge legal liability.
Exactly. If a teacher calls out sick or a shift runs long, you suddenly have to pay premium overtime just to stay compliant with the law. Amanda's flexible model prevented unnecessary overtime staffing, which saved Bright Horizons a significant amount of money.
But the real brilliance of that scheduling model, especially from a human resources perspective, is that it simultaneously protected the teachers.
How so?
Well, often when corporations cut overtime, they also cut base hours, right?
Yeah.
Which causes employees to lose their full-time status and their healthcare benefit.
Oh, wow. Yeah, that happens all the time in retail.
Exactly. But Brooks figured out a mathematical and administrative balance where corporates saved on premium pay, but the staff maintained their crucial full-time status even if they needed a flexible day off.
That is incredibly smart.
It is. That kind of administrative ingenuity requires deep operational understanding. Usually, that is exactly the kind of systemic improvement that corporate leadership fast-tracks for wider implementation across the whole company.
But she didn't stop scheduling either. She was actively building community and fostering leadership among her staff. She created something called DVCo.
Right, the development cohort.
Yes. It was a mentorship group specifically designed for teachers who wanted to stretch their assignments and grow into leadership roles. And on top of all that, she co-chaired the Bright Horizons Diversity and Inclusion Council.
So, legally speaking, the plaintiff is demonstrating that she was operating far above the standard expectations of a single-site director. She is essentially performing executive-level organizational development tasks.
Right. She's fixing systemic inefficiencies and building talent pipelines.
Exactly. All of this establishes a rock-solid baseline of exceptional performance before the management structure changes.
And that baseline is put to the ultimate stress test in March 2020. The COVID-19 pandemic hits. New York City becomes the global epicenter.
A really terrifying time, especially for childcare.
Unprecedented. So, Bright Horizons closes the West 96th location, and they pivot Amanda to become a field director at their Columbus Circle location, which is one of their flagship centers. She turns that place around, implementing her flexible scheduling and community building initiatives under extreme duress.
And then they move her again, right?
Yes. In October 2020, they move her to be the director at the Weill Cornell Children's Center at East 62nd Street.
We really need to pause and emphasize the unique environmental context of that specific location. Weill Cornell is a major medical center in New York City.
Right, it's a huge hospital system.
Yeah. The parents of the children at this daycare are not corporate executives working from home on Zoom. They're medical professionals, doctors, nurses, first responders.
Wow, so they're literally on the front lines.
We are talking about the absolute height of the pandemic, pre-vaccine, serving the people fighting a generational health crisis. The pressure on that facility must have been unimaginable.
And the complaint outlines that on top of her regular, already demanding duties as director, Amanda is managing all the COVID-19 related communications from these frantic parents.
Which is a full-time job in itself.
Exactly. She and her health and safety director are managing contact tracing for more than 100 students and teachers. They're fielding up to 20 emergency calls a week during the Omicron outbreak.
And constantly coordinating with the Bright Horizons corporate COVID team.
Right, and somehow keeping the center running smoothly so these doctors can go intubate patients.
It requires a massive amount of operational discipline, crisis management skills, and emotional intelligence to manage a facility under those conditions. And based strictly on the pleadings, she was succeeding remarkably well. She was carrying a tremendous burden for the corporation.
Okay, so I am looking at this resume and this track record, and I'm thinking, this is a superstar. This is the exact kind of employee a massive corporation should be moving mountains to retain and promote.
You would think so, yes.
But I've noticed a pattern in these employment disputes we cover. It seems like sometimes being a high achiever, being the person who innovates and changes the status quo, actually makes you a bigger target when new management arrives.
Oh, without a doubt.
Like if a new boss comes in who doesn't know your history or perhaps feels threatened by your competence, all those innovations suddenly become liabilities.
That is an incredibly common dynamic. A sudden change in leadership is frequently the catalyst for a shift in workplace culture, and it's often the beginning of differential treatment.
Because the new boss wants to mark their territory.
Exactly. New managers often want to establish their own authority, and a highly competent, independent subordinate can disrupt that objective. Which brings us to the pivotal reorganization in December 2020.
Right. Enter Robin Carone. In December 2020, Bright Horizons reorganizes its regional management structure and appoints Carone as the regional manager for the Weill Cornell Centers. This makes her Amanda Brooks's direct supervisor.
And the complaint establishes a very specific demographic dynamic at this point, which is crucial for the listener to understand.
What was the breakdown?
Carone supervised approximately half a dozen directors in her new region. Amanda Brooks was the only Black director under Carone's supervision.
Wow. The only one.
The only one. In a discrimination lawsuit, establishing who is in the room and what the power dynamics look like is the very first step in building a case for disparate treatment.
And the friction between them is not a slow burn at all. It happens almost immediately. In January 2021, during one of their very first one-on-one meetings, Carone looks at Amanda and says, "You are not Lee Mirror."
Which requires some context.
Right. For context, Lee Mirror was Amanda's previous regional manager, the one who had mentored her, supported her innovations, and basically given her the Rising Star Award.
So Carone is implying she's going to be much harsher. She's suggesting that Mirror was too soft on Amanda.
Exactly. And then shortly after that, Carone explicitly tells Amanda to her face, "I don't trust you."
I don't trust you. I mean, that is a highly aggressive, deeply unusual way to establish a new managerial relationship with a seasoned, successful professional.
It's basically a declaration of war on day one.
It really is. In a corporate environment, unless an employee has a history of severe disciplinary issues or financial misconduct, there is a baseline level of professional trust assumed. To verbally strip that away on day one signals a hostile intent that the law takes very seriously when combined with other factors.
It's totally bizarre, and the complaint alleges that Carone did not treat the other non-Black directors this way. Amanda noticed Carone was friendly, collegial, and supportive with the other directors, but treated Amanda with hostility and deep suspicion.
And how did that suspicion actually manifest day to day?
It manifested in a truly exhausting level of extreme micromanagement. The details are almost comical if they weren't so demeaning.
When a plaintiff is trying to prove differential treatment, courts are looking for tangible, documented evidence. They want to see how the plaintiff was treated differently than similarly situated peers outside their protected class.
Well, the micromanagement details definitely provide those granular facts. So Carone demanded to be copied on every single email Amanda sent, no matter how routine. She demanded to be invited to every single staff meeting Amanda held.
Which is just a massive waste of regional managers' time, frankly.
Right. But it gets worse. She even demanded to be consulted on which snacks to order for the children.
Snack orders.
Yes. Think about the cognitive dissonance there. Amanda is running a contact tracing operation for 100 people during a lethal pandemic, and her boss is demanding oversight on whether they order goldfish crackers or pretzels.
Believe it or not, the absurdity of the snack orders is actually a really strong legal point for the plaintiff.
Wait, really? Because I would think that micromanagement is just a sign of an insecure, bad boss. How does the law tell the difference between a boss who is just a controlling jerk to everyone and a boss who is actually discriminating?
That is the crucial distinction you have to make. Title VII and Section 1981 do not protect you from a boss who is an equal opportunity tyrant.
So if she was a jerk to everyone, it's legal.
Exactly. If Carone demanded to see snack orders from all 6 of her directors, Amanda would not have a discrimination claim based on that behavior.
Right.
The law doesn't police bad management. It polices discriminatory management.
Okay, I see.
The legal mechanism here requires isolating race as the only variable. By alleging that Carone specifically exempted the non-Black directors from copying her on emails or clearing snack orders, Brooks is arguing that the micromanagement was a pretextual tool used exclusively to harass the lone Black director.
That makes a lot of sense. It isolates race as the differential factor. And Carone's instructions were constantly shifting too, which created this incredibly chaotic environment.
Like moving the goalposts.
Yes, exactly. One week she'd tell Amanda, "You need my explicit permission to send a kid home for COVID symptoms." The very next week, when Amanda encounters a symptomatic child and asks for that exact permission, Carone snaps at her, "Why are you asking me this? You need to be more proactive."
It leaves the employee in a constant state of anxiety. You're unable to make a single decision without fear of reprimand.
Right, you're paralyzed.
It creates an unwinnable scenario. It's often referred to in organizational psychology as a double bind. The employee is punished for taking initiative and simultaneously punished for seeking guidance. Over time, this systematically erodes the employee's authority and confidence.
Which sets the stage for formal disciplinary action down the line.
Exactly. It's building a file.
And this tension wasn't just confined to administrative tasks like emails and snacks. It quickly bled into the broader cultural initiatives that Amanda had built.
Right. Let's talk about the Diversity and Inclusion Council.
Let's look back to the summer of 2020. This is actually before Carone was even Amanda's direct boss. This was amidst the nationwide anti-police brutality protests following the murder of George Floyd.
A very tense time for corporate culture across the country.
Absolutely. So the Diversity and Inclusion Council that Amanda co-chaired was holding teleconferences to provide a space for staff to process these heavy cultural issues. Robin Carone, a white employee, decides to attend one of these meetings. She immediately announces that she had been afraid to join previously because of her pro-police stance. She states publicly to the group that she can understand the police perspective on the murders of Black civilians.
Wow. Dropping that specific phrasing into a corporate diversity and inclusion space during the summer of 2020 is a highly charged action.
It's incredibly disruptive.
It fundamentally shifts the power dynamic of the meeting. It takes it from a supportive space for marginalized employees and turns it into a space centered on the defensive posture of a white member of management.
But Amanda handles it like a seasoned professional. She neutrally responds to Carone, stating that the council is a non-judgmental space where everyone is welcome for respectful discourse.
She de-escalates.
Right. But Carone won't let it go. She pushes further, telling Amanda directly that she fears she will be discriminated against at Bright Horizons because her husband is a police officer.
So she's claiming victimhood in that space.
Yes. So Amanda, trying to de-escalate again, asks Carone if she feels she is currently being discriminated against in any way. Carone declines to answer. Amanda even mentions that her own father was a police officer, attempting to build a bridge of shared experience. But Carone completely ignores the olive branch.
The inclusion of this specific interaction in the 38-page complaint serves a really vital purpose.
What does it signal to the court?
It establishes an interpersonal and cultural tension regarding race, authority, and perceived victimhood early in their dynamic. It suggests to the court that Carone harbored specific anxieties or resentments regarding race and the D&I initiatives before she ever assumed supervisory power over Brooks.
And once Carone does assume that supervisory power, she actively goes after the very things that made Amanda successful. She systematically dismantles Amanda's wins.
Let's talk about the scheduling.
Remember that flexible scheduling model that saved the company money and protected the teachers' benefits? Carone completely bans it. She tells Amanda she has to stop doing it because it's not the Bright Horizons way.
Not the Bright Horizons way. That is a fascinating piece of corporate jargon right there.
It sounds so vague.
It is. From a legal standpoint, phrases like not our culture or not our way are highly scrutinized in discrimination cases. Because they are entirely subjective and undefined, they are frequently used as a pretext to shut down initiatives or terminate employees without having to provide a concrete, data-driven business justification.
Well, Carone does attempt to provide a justification by claiming that teachers had been complaining about the flexible scheduling. But when Amanda asks for specifics like which teachers were complaining and what exactly were their concerns, Carone flatly refuses to elaborate.
Because there probably weren't any complaints.
Right, especially since all the direct feedback Amanda received was overwhelmingly positive. It acts as a phantom complaint. It's an invisible shield used to justify killing a program that gave Amanda internal prestige.
And the dismantling doesn't stop with the scheduling. The complaint details how Carone also targeted DVGO, that professional development cohort Amanda created to help minority teachers advance.
Right. In January 2022, Carone launches a formal HR investigation into DVCO. She aggressively accuses the group of racial favoritism.
He's on one.
Carone tells Amanda that she has heard that Latinx teachers felt the group favored Black teachers, and Black teachers felt it favored Latinx teachers. She uses this as justification to try and shut the whole mentorship program down.
Wow.
But the investigation runs its course and concludes with absolutely zero findings of wrongdoing. The accusations were entirely baseless.
This really illustrates the weaponization of the human resources apparatus.
The process is the punishment.
Exactly. Even when an employee is cleared of wrongdoing, having your passion project investigated for racial bias by a white supervisor who has already explicitly stated she doesn't trust you, that causes profound psychological damage. Furthermore, it damages your reputation and authority within the organization.
Because people just remember the investigation.
Right. The rumor mill doesn't always care about the official findings. It just remembers that you were investigated.
It's like trying to prove climate change by looking at a single rainy day. On its own, demanding to see snack orders is just a weird rainy day. Investigating a mentorship program is just corporate bureaucracy.
Right, but you have to zoom out.
Exactly. When you aggregate dozens of these rainy days, the shifting rules, the phantom complaints, the baseless investigations, and you apply them exclusively to the only Black director, you establish a climate of discrimination.
And the most glaring example of Carone setting Amanda up to fail revolves around those strict COVID protocols.
Yes, this brings us to a pivotal narrative moment, the incident with the twins in April 2021.
The mechanics of this incident perfectly highlight the double bind we discussed earlier.
So Carone orders Amanda to quarantine a pair of twins. She demands that Amanda keep these children out of the daycare center for 10 days. But Amanda, doing her due diligence as a director, had already spoken directly to the Bright Horizons corporate COVID team.
The actual experts.
The actual experts. And they explicitly told Amanda that these specific children did not need to quarantine because, according to their tracking, the twins had not actually been exposed to COVID. Amanda explains this to Carone. She's literally just relaying the company's own official health guidance.
Keep the environmental context in mind here. A 10-day loss of childcare for first responders at a major medical center during a pandemic is a massive, highly stressful disruption.
They can't go to work at the hospital.
Right. A director cannot casually enforce a quarantine without ironclad justification.
Exactly. The stakes are huge for these parents. But Carone refuses to back down. She tells Amanda that unless the corporate COVID team speaks to her directly, she won't change her mind.
Which is just an ego trip.
And when Amanda reiterates that she is just following the COVID team's established protocols, Carone completely loses her temper. She yells at Amanda, "Why are you talking to the COVID team? Who told you to talk to them?" And then she accuses Amanda of going rogue.
Let's analyze that phrase, going rogue, in this specific context.
That phrase stood out to me immediately. It's like being forced to steer a ship into a storm, but your captain is hiding below deck and blaming you for the weather.
That's a great analogy.
Amanda is the field director on the ground. It is literally in her job description to coordinate with the COVID team. The phrase going rogue carries heavily loaded, racialized connotations when it is directed at a Black woman who is simply trying to follow the established corporate policy.
Absolutely.
It implies she is dangerously insubordinate, out of control, and unpredictable.
The legal argument here is that this characterization relies on implicit bias. It leans into gendered and racialized stereotypes depicting Black women as inherently angry or defiant when they demonstrate competence or push back on incorrect instructions. And the immediate aftermath of this confrontation reveals the true managerial intent.
Oh, the aftermath is incredibly manipulative. The parents of the twins are absolutely furious, as anyone would be. They want to know why their kids are banned for 10 days without cause. Amanda, trying to manage the fallout, asks Carone for guidance on what to communicate to them. Carone orders Amanda to enforce the strict 10-day quarantine, but then explicitly forbids Amanda from telling the parents that it was Carone's decision.
Wow.
She forces Amanda to absorb the parents' rage and take the professional blame for a baseless policy that Amanda actively tried to prevent.
By forcing the subordinate to act as the human shield for a bad management decision, the supervisor intentionally damages the subordinate's relationship with her clients. This fits perfectly into the broader mosaic of disparate treatment. The plaintiff is sacking these incidents to show a deliberate campaign to undermine her ability to perform her job.
So we have this incredibly toxic, contradictory environment brewing daily. But hostile management is one thing. Messing with an employee's livelihood is another.
Right, it eventually hits the wallet.
This administrative friction inevitably bleeds into Amanda's actual paycheck and her career mobility. Let's examine how this escalating tension impacts her professional trajectory, starting in April 2021.
This is the phase where the allegations shift from daily interpersonal hostility to tangible economic career impacts.
Despite all this engineered friction from Carone, Amanda's objective metrics are still so good that in April 2021, she is actually promoted to executive director. She is now tasked with managing 2 Weill Cornell locations simultaneously, the 62nd Street location and the 60th Street location.
That's a huge step up in responsibility.
It is. But for taking on the responsibility of an entire second facility, her salary increases by a whopping $1,000 a year, which in New York City feels absurdly low for doubling an executive's workload.
The $1,000 increase for a massive expansion of duties is highly irregular for an executive-level promotion. It signals a deep devaluation of her labor.
And the promotion comes with incredibly messy reporting structures that seem designed to fail. Amanda is supposed to supervise Jenny Bay, who is the existing director at the 60th Street location, but Carone steps in and tells both of them that Bay will also continue to report directly to Carone,
Which completely undermines Amanda's authority.
Instant confusion. Carone repeatedly refuses to provide a clear, written job description for Amanda's new, expanded role. However, despite the structural chaos, Amanda and Jenny Bay actually hit it off. They build a solid, supportive working relationship.
And it is important to note the demographic reality here. Jenny Bay is an Asian American woman.
Yes. And as their trust builds, Bay starts confiding in Amanda about her own experiences with regional management. She tells Amanda that Carone is treating her terribly. Bay describes feeling like she's constantly walking on eggshells.
Sound familiar?
Exactly. She details how Carone speaks to her aggressively, is utterly dismissive of her concerns, provides zero operational training, and that Bay genuinely feels Carone is purposefully setting her up for failure. Crucially, Bay confides to Amanda that she feels marginalized and targeted by Carone specifically because she is Asian.
This is a critical juncture in employment law. An employee has just brought a specific, protected complaint of racial discrimination to her immediate supervisor. The law mandates how a supervisor must respond to this.
And Amanda responds exactly how a competent, ethical manager is supposed to. Between April and October 2021, she formally reports Bay's complaints up the chain of command to Carone multiple times.
She did it by the book.
She tells Carone directly that Bay feels unsupported and feels she is being subjected to disparate treatment because of her race. And how does Carone, the regional manager, respond to this serious allegation of civil rights violations? She shrugs and says she'll have to figure it out.
That response is a complete abdication of managerial, human resources, and legal responsibility. When a corporation is put on notice of potential racial harassment, ignoring it creates massive liability.
Ultimately, the unaddressed harassment becomes too much to bear, and in October 2021, Jenny Bay resigns.
Predictably.
Yes, and predictably, Carone attempts to falsely blame Amanda for Bay's departure, claiming Amanda failed to support her subordinate. However, the truth leaks out. Another employee later informs Amanda that Carone was actually bragging behind closed doors, stating she regretted hiring Bay and that Bay was a sore spot for her.
By repeatedly reporting Bay's claims of racial discrimination to management, Amanda Brooks has engaged in what federal law designates as protected activity.
Meaning she can't be fired for it.
Right. This means she has legally shielded herself, in theory, from retaliation for blowing the whistle, but the protections of the law are only as strong as the courts interpreting them, as we will soon see.
Almost immediately after engaging in this protected activity, Amanda's own upward mobility hits a brick wall. In November and December of 2021, Amanda applies for an open regional manager role. This would be a massive step up, taking her out from under Carone's direct supervision.
Which I'm sure she desperately wanted.
Of course. Given her history of running multiple flagship centers during a pandemic, she easily makes it to the final round of interviews. But she is ultimately passed over. Instead, Bright Horizons hires a man named Antonio Lopez.
The complaint notes that Lopez is a Latino man, meaning he is also a minority. But when analyzing a failure to promote claim, the court must look deeper than just demographics. It must look at the objective qualifications. What was Antonio Lopez's background compared to Brooks?
This is where it gets infuriating. The job posting for the regional manager position explicitly listed prior supervisory experience as a mandatory requirement. Antonio Lopez had no prior supervisory experience, zero.
So he didn't even meet the baseline requirements.
None. So the corporation actively chooses to hire a man who lacks the mandatory baseline requirements over a Black woman who has spent years successfully directing their most complex, high-stakes medical center locations.
Now, I can anticipate a listener thinking, well, maybe Lopez had incredible interview skills or some other intangible quality that made him a better fit.
Right. Companies can hire for fit.
The law does allow corporations to use subjective criteria. However, when an employer ignores its own explicitly stated objective requirements to hire someone outside the plaintiff's protected class, it creates a very strong inference that the subjective reasons are merely a pretext for discrimination.
And the pretext crumbles completely when Amanda asks for an explanation. She asks Carone directly why she wasn't selected for the promotion, and Carone delivers the comment that becomes the central focus of the entire litigation.
This is the smoking gun.
She tells Amanda that part of the reason she didn't get the job was because she lacked experience managing people not like her.
Not like her. That is a phrase that demands intense scrutiny from a judge.
Amanda is understandably shocked. She is the only Black director in the region. Almost everyone she manages is not like her demographically. So she presses Carone for clarification. What exactly does not like her mean?
And how did Carone try to spin that?
Carone attempts to justify the comment by pointing to two specific employees. Jenny Bay, the Asian woman who quit because Carone was allegedly harassing her, and another employee named Miss Arizari.
The context surrounding Mrs. Arizari is a perfect example of how discriminatory management weaponizes a plaintiff's success.
Right. Mrs. Arizari is a Latina employee whom Amanda had actually successfully mentored. Irizarry wanted a fresh start away from some interpersonal drama happening at the 62nd Street location, so she came to Amanda and requested a transfer to the Bright Horizons location in DMAU, Brooklyn.
A totally normal HR move.
Completely normal. Amanda, being a supportive manager, facilitated the transfer. Irizarry thrived in DMBO and even reached out to thank Amanda for setting her up for success. But Carone twists this entirely positive management outcome.
She spins it as a failure.
Exactly. Carone claims Amanda transferred the problem away and uses this successful facilitation as evidence that Amanda cannot manage people not like her.
The employer is taking the plaintiff's objective successes, supporting an employee's voluntary transfer to a better fit, advocating for a subordinate facing discrimination, and reframing them as fatal leadership flaws to justify denying her career advancement.
It's a dizzying level of gaslighting, so let's tally this up. Amanda has been passed over for a promotion in favor of an unqualified candidate. Her successful programs were attacked and baselessly investigated, and she's being subjected to relentless micromanagement. The pressure cooker finally bursts in February 2022 when Amanda raises a formal complaint about pay inequity.
This meeting in February 2022 represents the second major instance of what Amanda argues is protected activity under the law.
Amanda calls a formal meeting with Anne-Marie Salmon, the division vice president, to discuss her compensation and her working conditions. Amanda points out a glaring objective inequity. She is the executive director of 2 facilities, yet she earns less money than one of her own direct reports.
Which is a huge red flag.
This direct report is Caroline Moran, a white woman who holds a more junior position and manages fewer responsibilities.
Discovering that you are managing a subordinate who is paid more than you is a textbook catalyst for a pay disparity claim, especially when the demographics differ.
And VP Salmon's response is a masterclass in corporate deflection. She coldly states that 3% is the maximum raise Bright Horizons can give anyone, regardless of the disparity.
Just quoting policy to avoid the issue.
Right. When Amanda asks if there is an objective pay grid or a formula to explain the logic behind Moran's higher salary, Salmon refuses to provide one and just repeats the 3% line. Recognizing she is getting nowhere on the math, Amanda uses this meeting to lay all her cards on the table.
She tells her everything.
Everything. She tells the VP how demeaned, targeted, and underappreciated she feels by Carone, detailing the constant chastising and the refusal to provide clear job boundaries.
If you are listening to this, you might logically assume that going to a vice president and stating, "My white subordinate makes more than me and my manager is treating me terribly," would force human resources to immediately throw a protective shield around you and launch an investigation.
That's exactly what anyone would think. You flagged a clear racial pay disparity in a hostile environment to a corporate officer. The law is supposed to protect you from being punished for speaking up, right?
It is supposed to. The legal concept of protected activity under Title VII is specifically designed to shield employees from retaliation when they blow the whistle on discriminatory practices. But as we transition into how the courts actually interpret this, we find that the exact vocabulary you use in that meeting matters more than the reality of the situation.
It's so frustrating.
It is. The courts draw an incredibly sharp, often unforgiving line between an employee complaining about general workplace unfairness and an employee formally complaining about unlawful civil rights violations.
And that rigid linguistic line is going to have devastating consequences for Amanda. The timeline accelerates at a terrifying pace after that February meeting with the VP. Less than 2 weeks later, the hammer drops. It's March 6th, 2022.
Things move very fast now.
Very fast. Carone calls Amanda and abruptly tells her she is banned from the building. She's not allowed to come to work, effective immediately. Why? Because there is an allegation against her and a pending investigation.
To heighten the psychological stress, they initially refuse to even tell her what the specific allegation is.
It's terrifying. You devote 5 years of your life to a company, run their hospitals through a pandemic, and suddenly you are locked out with no explanation. Eventually, Carone informs her that the suspension is related to a breach of COVID protocols.
But the underlying facts of this alleged breach are absolutely staggering.
They really are. The protocol violation didn't happen at Amanda's primary center. It happened at a center run by Caroline Moran.
Just to ensure you listening can track the players here, Caroline Moran is the junior white director who was making more money than Amanda Brooks.
Yes. Caroline Moran was the person on the ground who actually made the decision that allegedly violated the Bright Horizons COVID protocol. But Moran is never investigated. She is never put on administrative leave. She is never penalized in any way whatsoever.
Completely ignored.
But Amanda, who was off-site and didn't even make the decision, is suspended, placed on unpaid administrative leave, and then on March 14th, 2022, she is officially fired.
And who does the corporation hire to replace Amanda as the new executive director?
A white woman. So let's look at the sheer audacity of this sequence. They fire the black executive director for a rule broken by her white subordinate. They completely ignore the white subordinate's culpability, and then they replace the black executive director with another white woman.
It's blatant.
And if that wasn't damaging enough, Bright Horizons engages in a post-termination cover-up that actively sabotages Amanda's future.
The external communication surrounding a termination is often where employers generate additional liability.
When Amanda is fired, HR tells her that to make things easier on the community, she should tell the daycare families that she resigned voluntarily.
To save face.
Right. But before Amanda even agrees to this lie, Carone proactively sends a letter to all the Weill Cornell parents stating that Amanda has resigned to pursue a new job opportunity. They essentially put out a press release saying it was an amicable split.
But behind the scenes.
When Amanda applies for new high-level teaching jobs with the city of New York, Bright Horizons responds to the background checks by telling those prospective employers that Amanda was fired for cause.
Labeling a termination as for cause without providing the nuanced context is a lethal blow to a professional career in education or healthcare. It implies severe misconduct, negligence, or ethical breaches.
It completely ruined her chances at securing those municipal jobs. This highly educated, award-winning director with a master's degree was forced to take a massive pay cut, eventually finding work as a low-level preschool assistant just to survive.
That's heartbreaking.
It essentially reset her hard-earned career all the way back to the bottom.
So, facing absolute professional ruin, Amanda Brooks takes her meticulous timeline, her documented emails, her pay data, and the specific quotes from her management, and she files a federal lawsuit.
The natural next step.
Yes. The case is assigned to the Southern District of New York, presided over by Judge Paul Engelmayer. In response, the defendants Bright Horizons and Robin Carone file a motion to dismiss the case under Rule 12b-6 of the Federal Rules of Civil Procedure.
Okay, if you are listening to this and wondering how Rule 12b affects you, it's a concept you need to understand because it is the biggest roadblock in the civil justice system.
Right.
What does a 12b-6 motion actually do?
A Rule 12b-6 motion is a defendant's best friend. It essentially asks the judge to look at the plaintiff's complaint and say, Your Honor, even if we assume that every single word this plaintiff wrote is 100% true, it still does not add up to a violation of the law. Therefore, you should throw this entire case out before we even begin discovery.
So it prevents you from even getting evidence?
Exactly. It is a procedural tool designed to stop the lawsuit in its tracks before the corporation is forced to endure the expensive and revealing process of handing over internal emails, pay grids, or subjecting executives to sworn depositions.
It's the legal equivalent of stopping a fight before the bell even rings. And Judge Engelmayer completely agrees with Bright Horizons. He grants their motion and dismisses Amanda's entire lawsuit.
He issues a brutal 23-page written opinion dismantling her claims.
I want to walk through exactly how he justified throwing this out. starting with the procedural hurdle of the statute of limitations.
The statute of limitations analysis requires us to look at the specific civil rights statutes Amanda is invoking. She is suing under two primary federal laws, Title VII of the Civil Rights Act of 1964 and Section 1981 of the Civil Rights Act of 1866.
Wait, hold on. 1866, as in the year immediately following the end of the Civil War. How does a law from the 19th century apply to a modern corporate daycare dispute?
The history of Section 1981 is profound and legally crucial. After the Civil War and the abolition of slavery, Southern states began passing black codes designed to restrict the economic freedom of formerly enslaved people.
Right.
In response, Congress passed the Civil Rights Act of 1866 over the veto of President Andrew Johnson. Section 1981 specifically guarantees that all persons within the jurisdiction of the United States shall have the same right to make and enforce contracts as is enjoyed by white citizens.
Okay, but how does that tie into employment?
In the modern era, the courts have interpreted an employment agreement, even an at-will employment relationship, as a contract. Therefore, if you are fired or denied a promotion because of your race, your right to make and enforce a contract has been violated under this 1866 law.
That is fascinating. So why does a plaintiff need both Title VII and Section 1981? Why not just use one?
Because they have vastly different procedural rules, most notably the ticking clock. Under Title VII, an employee has a very tight, unforgiving window to take action. You must file a formal charge of discrimination with the EEOC, the Equal Employment Opportunity Commission, within 300 days of the specific discriminatory act.
300 days.
If you miss that deadline by even one day, your Title VII claim is dead forever.
Section 1981, however, does not require an EEOC filing and boasts a much longer 4-year statute of limitations.
And Judge Engelmayer uses that 300-day clock to slice Amanda's case in half. Amanda officially filed her EEOC charge on January 1st, 2023. If you count back exactly 300 days from that date, you land on March 7th, 2022.
Which is an incredibly problematic date for her timeline.
It's devastating because it means that anything that happened before March 7, 2022 is legally erased as an independent Title VII claim. The December 2021 denial of the promotion.
Fair rate. All micromanagement. All the intense micromanagement, the baseless DVCO investigation, the refusal to let her use flexible scheduling, erased. The judge says, sorry, you were too late on those specific incidents to claim them under Title VII.
But as we noted, Section 1981 has a 4-year statute of limitations. So the core claim regarding the failure to promote her to regional manager in December 2021 easily survives the time limit under that older statute.
Right, because it was only a few months prior.
However, surviving the clock doesn't mean surviving the judge. Engelmayer still dismisses the core race discrimination claims across the board under both statutes.
And his reasoning on the merits of the discrimination is so deeply frustrating to read because it feels entirely divorced from human reality. He writes that Amanda's complaint lacked factual amplification.
Which means what to him?
He looks at the specific documented quotes from Carone telling Amanda she was going rogue, telling her she needed more experience managing people not like her, telling her to be mindful of perception because her questions were too pointed and direct.
How does the district court judge interpret the underlying intent of those specific phrases?
He strips them of all context and calls them facially neutral. He rules that they are not coded references to race. He basically argues, well, going rogue just means breaking the rules. Being pointed just means you are blunt. Managing people not like you could just mean managing people with different personality types. None of this explicitly mentions race, therefore it isn't racial.
This specific ruling highlights a massive ongoing debate regarding how the federal judiciary understands modern workplace culture and implicit bias.
It feels like they're living in the past.
The judge is requiring almost cartoonish explicit racism, like the use of a slur, to acknowledge discriminatory intent at the initial pleading stage. He is completely ignoring the environmental context of a white supervisor looking at her only black director who is just doing her job and labeling her rogue or too pointed, while giving the white directors a complete pass for actual protocol violations.
It feels like he is analyzing the words in a sterile vacuum, completely ignoring the power dynamics and the historical weight of those tropes. But the most alarming part of his ruling is how he handles the retaliation claims. He throws those out completely, too.
The dismissal of the retaliation claims is where the strict mechanics of the law truly punish the employee. Let's examine his logic regarding the February pay complaint with the vice president. Why did he rule that complaining about a severe pay disparity wasn't protected activity?
Because Amanda didn't explicitly use the magic word race in the meeting. She pointed out the objective fact that Carolyn Moran, a white woman with less responsibility, made more money than her. But because Amanda didn't explicitly say the sentence, I believe this disparity is due to racial discrimination, Judge Engelmeyer ruled that Bright Horizons wasn't officially on notice of a civil rights complaint.
So he just saw it as a normal complaint.
Right. He decided that she was just a disgruntled employee complaining about standard corporate unfairness, not a whistleblower reporting unlawful bias.
That is an incredibly rigid interpretation of human interaction. It requires employees to speak like seasoned civil rights litigators when they're sitting in a stressful HR meeting, rather than speaking like normal professionals describing a factually unfair situation.
Right. Who talks like that in real life?
Nobody. If you point to a white employee making more money than a black employee for less work, the underlying implication should be obvious to any competent HR professional.
But wait, what about her reporting Jenny Bay's complaints? Bay explicitly told Amanda that she felt targeted because she was Asian. Amanda reported that exact phrasing to Carone multiple times. That has to be undeniable protected activity, right? There is no ambiguity there.
You are correct, and the judge acknowledges that reporting Bay's complaints did indeed qualify as protected activity. However, he still dismisses the retaliation claim based on a legal doctrine known as temporal proximity.
Temporal proximity, basically the timeline of cause and effect. Can you explain how the courts use this?
To prove retaliation, a plaintiff has to show a direct causal link between their protected activity and their punishment. Because employers rarely send an email saying, "Let's fire Amanda because she complained about civil rights," courts have to rely on circumstantial evidence, primarily timing.
Okay.
The logic is simple. If you complain on Monday and get fired on Tuesday, the temporal proximity is so tight that it strongly suggests retaliation. The closer the events, the stronger the inference.
But the judge looks at Amanda's timeline and decides the gap is simply too big. Amanda last reported Bay's issues to management in October 2021. She was denied the promotion to regional manager in December 2021, which is a 2-month gap. And she was fired in March 2022, which is a 5-month gap.
So he says that's too long.
Yes, Judge Engelmeyer cites legal precedent stating that anything beyond a 2- or 3-month gap is too attenuated to prove causation based on timing alone.
The practical effect of this ruling is deeply cynical. It incentivizes corporations to be patient with their retaliation. If a company wants to punish a whistleblower, all they have to do is wait 90 days. Once a business quarter passes, the legal presumption of causation vanishes, and the employer can fire the employee with significantly less risk of a retaliation lawsuit.
So the district court wraps all of this up, signs the order, and throws the entire case out of court. Amanda Brooks is left with no job, a damaged reputation that destroyed her public sector prospects, and a federal judge formally telling her that she doesn't even have enough evidence to warrant a basic trial. It is a total defeat.
Which brings us to the unexpected glimmer of hope in June 2026, the Second Circuit reversal.
Yes. Fast forward to June 2026. Amanda's legal team appeals Judge Engelmeyer's decision, and the case lands before the Second Circuit Court of Appeals. This court sits just one step below the United States Supreme Court.
This is where the appellate process demonstrates its essential value in correcting overly rigid lower court decisions.
The appellate judges review Engelmeyer's ruling and say, hold on a minute, you interpreted the pleading standards entirely wrong. They issue a ruling that partially reverses the lower court and breathes life back into Amanda's lawsuit.
Let's break down exactly what the Second Circuit revived, starting with the core discrimination claims.
First, they look at the failure to promote her to regional manager. Remember, this claim survived the time limit because it fell under the 4-year window of Section 1981. The Second Circuit forcefully declares that Amanda absolutely met the minimal burden required to survive a motion to dismiss.
And what specific facts did the appellate court rely on to reach a completely different conclusion than the district judge?
The Second Circuit looked at the aggregate picture, the climate change analogy we used earlier, that the lower court willfully ignored. They pointed out that Amanda was objectively qualified for the role. The man they hired over her, Antonio Lopez, explicitly lacked the mandatory supervisory experience listed in the job description.
So that objective mismatch was key.
Exactly. Furthermore, she alleged that Carone subjected her to intense micromanagement, the emails, the meetings, the snack orders, while completely leaving the non-Black directors alone. The Second Circuit says that is the very definition of differential treatment.
Right.
When you pair differential treatment with the hiring of an unqualified candidate over a qualified minority, that is more than enough to suggest discriminatory intent and allow this case to proceed to discovery.
The appellate court also revived the most critical claim, the discrimination claim regarding her actual termination.
Yes. The Second Circuit zeroes in on the ultimate comparator argument. Can you explain what a comparator is in this context?
In employment law, a comparator is someone in a sufficiently similar situation to the plaintiff, but outside of their protected demographic class, who receives more favorable treatment from the same management.
Okay, so a peer.
Yes. Finding a nearly identical comparator is the holy grail in a discrimination suit because it perfectly isolates race or gender as the only plausible reason for the disparate treatment.
And the Second Circuit recognizes that Amanda had practically a perfect comparator. They highlight the glaring hypocrisy of the COVID protocol breach. Amanda was fired because of a rule broken by Caroline Moran, a white woman. But Moran, the actual rule breaker, wasn't punished at all.
And then they replace Amanda with a white woman.
Right. The appellate court says this scenario easily creates a plausible inference of racial discrimination. You simply cannot fire the black boss for the white subordinate's mistake, let the white subordinate off the hook, and pretend there is no legal inference of bias.
This analysis leads to a fascinating and highly technical clash between the courts regarding how to apply legal precedent. In his initial dismissal, Judge Engelmayer relied heavily on a previous case called Marcus v. Leviton to justify throwing out Amanda's claim. He used it to argue that just because she was replaced by a white woman, it didn't mean anything legally.
I noticed the Second Circuit was very aggressive in correcting him on this point. How does precedent actually work here? Why was the judge wrong to use Marcus?
It comes down to the hierarchy of court decisions. Marcus v. Leviton was what is known as a summary order.
What's that?
A summary order is a brief, non-precedential decision issued by an appellate court when they feel a case is straightforward and doesn't require a full, published, binding opinion. In Marcus, the court had ruled that merely being replaced by someone outside your protected class without any other supporting evidence isn't enough to prove discrimination.
Okay, so Engelmayer used that to say Amanda's replacement didn't matter.
Right. However, the Second Circuit issues a sharp rebuke, reminding him that a non-binding summary order like Marcus cannot override binding published precedent. They point him to a landmark published opinion called Littlejohn.
And what does Littlejohn say?
Littlejohn established that at the initial pleading stage, an employee doesn't have to prove their entire case. They only need to provide enough facts to make the claim plausible. Furthermore, the Second Circuit points out a massive factual difference. In the Marcus case, the plaintiff had submitted skeletal pleading, meaning they barely provided any facts at all other than I was fired and replaced.
Right. And the Second Circuit says Amanda Brooks's 38-page, highly detailed complaint is the exact opposite of skeletal. She didn't just say she was replaced. She provided a granular history of differential treatment, the documented micromanagement, the weaponized HR investigations, the specific quotes from Carone, and the disparate punishment regarding the COVID breach.
That's a mountain of facts compared to Marcus.
Exactly. When you pair all those specific details with the fact that she was replaced by a white woman, the Second Circuit declares that is absolutely enough to get past a motion to dismiss.
It is a massive structural victory for the plaintiff. Surviving a 12b6 means she has unlocked the doors to discovery. She now has the legal power to subpoena internal Bright Horizons emails, demand the corporate pay grids, and force Robin Carone and VP Anne-Marie Salmon to sit for sworn depositions. She gets to fight her case based on actual evidence, not just initial allegations.
But we have to acknowledge that it is a mixed victory. There is a very bitter pill to swallow here. Because while the Second Circuit rightly revived the core discrimination claims, they completely agreed with the district court on the retaliation claims. The retaliation claims stay dead.
This outcome represents the hardest, most counterintuitive part of employment law for plaintiffs to accept.
Let's go back to that pay complaint with VP Anne-Marie Salmon. The Second Circuit upholds the lower court's ruling. They agree that pointing out a white subordinate makes more money than you is not enough to put a company on notice of a protected civil rights complaint.
The appellate court affirms the strict linguistic standard. They state that unless an employee explicitly suggests the disparity is because of unlawful discrimination, meaning you must utter specific trigger words like race, discrimination, or bias, you have not engaged in protected activity under the law.
Even with the obvious demographics right in front of them.
even then, even if the comparator happens to be a different race, a general complaint about unfair pay is legally treated as nothing more than complaining about a bad boss or a rigid corporate compensation structure. It garners zero protection from retaliation.
That is maddening. It places an impossibly heavy burden on the employee to diagnose the exact legal nature of their mistreatment in real time. You are sitting in a highly stressful meeting with an executive discussing your livelihood, and the courts expect you to invoke statutory language just to protect yourself from being fired.
And the Second Circuit also upheld the strict mechanical rules on temporal proximity regarding Amanda reporting Jenny Bay's complaints.
Yes, they affirmed that the 2-month gap between her last complaint about Bay and the denial of her promotion and the 5-month gap to her termination is simply too long in the eyes of the law to prove that the complaint caused the firing, absent any direct smoking gun evidence like an email admitting retaliation.
So as we wrap up this discussion on the mechanics of the system, let's summarize the sheer volume of hurdles we just uncovered.
Amanda Brooks was an award-winning, highly educated, successful director who carried a medical center through a pandemic. She documented everything. She had witnesses. She had clear comparators. And yet she was entirely thrown out of court on the first try because pleading standards require an almost impossible level of explicit proof before discovery is even allowed.
The overarching lesson here is that the exact words used, both the coded language used by managers to harass you and the specific vocabulary you choose when you try to report it to HR, can entirely dictate the outcome of a federal lawsuit years later. The courts demand a level of linguistic precision and formal notice that rarely, if ever, exists in real-world human interactions.
Think about the chilling retaliation catch-22 we just explored. If you go to human resources to complain about an obvious racial pay disparity, but you try to be polite, you try to keep it professional, and you purposefully avoid throwing around heavy, combative legal accusations like racial discrimination, the courts say your employer isn't legally on notice. You might be fired 2 weeks later in blatant retaliation, and the law will essentially look the other way. Does the legal system, as it is currently interpreted, essentially require every single employee to act like a hostile, paranoid litigator the very moment they step into an HR office just to preserve their basic civil rights?
If you like the Employee Survival Guide, I'd really encourage you to leave a review. We try really hard to produce information to you that's informative, that's timely, that you can actually use and solve problems on your own and at your employment. So if you like to leave a review anywhere you listen to our podcast, please do so. And leave 5 stars, because anything less than 5 is really not as good, right? I'll keep it up. I'll keep the standards up. I'll keep the information flowing at you. If you'd like to send me an email and ask me a question, I'll actually review it and post it on there. You can send it to mcarey@capclaw.com. That's capclaw.com.